All protocols are observed. And this afternoon, it gives me great pleasure on behalf of the Assembly of Southern Lawyers to welcome each and every one of you to our annual end-of-term luncheon. Today is always one of my favorite occasions on our calendar. It is an opportunity for us to pause on the demands of litigation, urgent applications, seemingly impossible deadlines, and an ever-growing running list which we all have, to celebrate our profession, and more importantly, the people who have shaped it. This afternoon, we are especially privileged to be joined by a man whose name has become synonymous with advocacy in Trinidad and Tobago as our guest of honor, Mr. Ramesh Lawrence Maharaj, Senior Counsel. Over the course of nearly 6 decades at the bar, he has served not only as one of this country's most foremost advocates, but also as Attorney General, whilst continuing to shape our constitutional and public law jurisprudence through advocacy at the highest levels. Like many members of my generation, my first introduction to Mr. Maharaj came long before I ever met him personally. It was during law school. As students, we read about his constitutional litigation arising from the famous contempt proceedings against him. We learned that what began as the imprisonment of an advocate for contempt ultimately produced landmark constitutional jurisprudence on due process, judicial fairness, and the availability of constitutional redress. Those were not simply interesting cases in a textbook. They reminded us that courage at the bar can shape the law itself. But by the time I was called to the bar and began appearing before our courts, I finally encountered Mr. Maharaj in person. I must confess that my first impression was one shared, I suspect, with many young attorneys. He was intimidating. When Mr. Maharaj walked through the corridors of the Hall of Justice, his presence alone commanded attention. Conversations became quieter. Young attorneys suddenly became very interested in their files. There was an unmistakable aura about him, not because he sought it, but because it had been earned through decades of advocacy at the very highest level. Fortunately for me, my introduction to Mr. Maharaj was not confined to seeing him across a courtroom alone. My mentor, Mrs. Lynette Maharaj, Senior Counsel, may she rest in peace, who has played an immeasurable role in my own professional development, introduced me to him in a more personal setting. Through her guidance, I came to appreciate not only the formidable advocate we all know, but also the gentleman behind the silk. As my years in practice progressed, something interesting happened. The initial intimidation that I felt subsided. It was not gone, mind you, but it was replaced with admiration. I came to appreciate that what distinguished Mr. Maharaj was not merely his brilliance or experience, it was preparation. Mr. Maharaj demonstrated to many of us that advocacy is not theater, it is discipline. When I eventually had the honor of working with him, watching him work taught me the true meaning of perspiration in this profession. We often hear that success is 1% inspiration and 99% perspiration. Welcome, Chief Justice. Mr. Maharaj exemplifies this principle. Excellence, I learned, is rarely accidental. It is built through preparation. And Chief Justice, this is one of the first things I learned from you in law school. Preparation, preparation, preparation. Through refusing to accept what is good enough, and through mastering every fact, every authority, and every possible argument before stepping into court. That standard has undoubtedly influenced generations of attorneys who have appeared alongside him, against him, or simply observed him from the back of a courtroom. The legal profession is fortunate to have individuals whose careers became examples for others to follow. Legends are not made by a single great case or a single public office. They are forged over decades through consistency, professionalism, courage, and an unwavering commitment to excellence. Mr. Maharaj's career exemplifies precisely that. On behalf of the Assembly of Southern Lawyers, I wish to express our sincerest gratitude that you have accepted our invitation to be with us today. Your career reminds us that advocacy is not simply about speaking well. It is about preparation, it is about conviction, it is about defending principles even when it is personally difficult to do so. And it is about leaving the law stronger than you found it. To our members, I wish to thank you for your continued support throughout this legal term. The Assembly exists only because of your participation, your collegiality, and your commitment to strengthening the profession in Southern Trinidad. I hope that today provides an opportunity not only to celebrate another successful legal term, but also to renew the friendships and professional relationships that make our bar such a remarkable community. Ladies and gentlemen, thank you for joining us this afternoon. Please enjoy the fellowship, the conversation, and the opportunity to celebrate yet another successful legal term. And more importantly, please join me in extending the warmest Assembly of Southern Lawyers welcome to our distinguished guest of honor, Mr. Ramesh L. Maharaj S.C.
Thank you very much, Jared. Good afternoon, everyone. It is a privilege to stand before you today on behalf of the Law Association of Trinidad and Tobago to join the Assembly of Southern Lawyers in honoring a man whose name has, for 60 years, been inseparable from the practice of law in this country, Mr. Ramesh L. Maharaj, Senior Counsel. 60 years. Let that number sit with us for a moment. 60 years since a young man from Diamond Village, having once considered a very different vocation in the priesthood, found himself instead drawn into a courtroom and knew almost instantly that this was where he belonged. He crossed an ocean to be called to the bar the Inner Temple in London in 1966 and returned home in 1967 to begin what would become one of the most consequential legal careers in the history of independent Trinidad and Tobago. From his earliest years in practice, Mr. Maharaj distinguished himself not merely as a competent attorney, but as a fearless one. He built his name representing the powerless, sugar workers, trade unionists, ordinary citizens who had nowhere else to turn. He tested the limits of executive power in the courts. Few lawyers can say they have shaped the jurisprudence of their nation as both advocate and litigant. Mr. Maharaj can see both. Nelson Mandela once said that he learned courage was not the absence of fear, but the triumph over it. If ever there was a Trinidad and Tobago lawyer who embodied that idea, it is the man we honor today. Brilliant, yes, but it has been his fearlessness, his willingness to take the harder case and the harder position when the easier path lay open before him that has truly set him apart as a trailblazer of this bar. That same fearlessness followed him into public life. As Attorney General from 1996 to 2001, he did not simply hold office. He used it to reshape the relationship between citizen and state. It was under his stewardship that Trinidad and Tobago saw the passage of the Freedom of Information Act, the Equal Opportunity Act, the Judicial Review Act, three pillars of transparency, equality, and accountability that continue to protect every citizen of the country today. He reformed the parliamentary committee system itself so that the institutions of government would answer more closely to the people they serve. These are not small achievements. They are the architecture of a more open society. And through it all, Mr. Maharaj never lost sight of what it means to be a lawyer first. He has told law students, in his own words, that the profession is not solely about making money, that every attorney carries a duty to give something back, to take up the cases that others turn away, to stand for people facing grave injustice even when it is costly to do so. That is not a philosophy he merely preached, it is one he lived, from his earliest days representing the voiceless to his continued human rights advocacy through the Trinidad and Tobago Civil Rights Association. But perhaps what speaks most to his character is not the courtroom victories or the legislation bearing his imprint, but the time he has always found for the newest members of our profession. Mr. Maharaj has never treated young lawyers as an afterthought. He has addressed law students and fresh graduates again and again, sharing not polished platitudes, but the honest lessons of life at the bar, urging them to take up pro bono work, to never turn away a litigant facing grave injustice, and to remember that this profession is a calling to serve, not merely a means to earn. That is the mark of a true trailblazer, not simply the ground he broke for himself, but the path he has spent a lifetime lighting for those who would follow. The Law Association has had the honor to work alongside Mr. Maharaj at various points on this journey, including welcoming him as our featured speaker at our annual dinner, honoring 50-year practitioners of this profession. He has assisted the association materially pro bono, for example, most recently in representing us in the silk litigation initiated by Mr. Israel Khan Senior Counsel. Today, it is fitting that we gather again, this time to mark 60 years, a milestone reached by vanishingly few in any profession, let alone one as demanding as ours. Mr. Maharaj, on behalf of the entire council and the membership of the Law Association of Trinidad and Tobago, please accept our deepest congratulations and our profound respect. You have shown generations of us what it means to use the law, not only as a shield for the powerful, but as an instrument for justice. You have shown us that courage in this profession is not the absence of risk, but the willingness to act rightly in spite of it. On behalf of the Law Association of Trinidad and Tobago, and I dare say on behalf of every lawyer in this room who has ever stood for a client with nothing but the law and conviction behind them, thank you, Mr. Maharaj. Congratulations on 60 extraordinary years. May there be many more.
Good afternoon, everyone. There is something I'm going to do today that I've not been able to do for over 40 years. And I'm going to save that for last. First of all, let me congratulate Syra, the Assembly of Southern Lawyers and the executive. Welcome, each and every one. Today is very, very special for me because this gentleman that we are recognizing is truly a legend in his own time. The DPP and I were just discussing, it is about recognizing in one's life what you've been able to achieve. But Mr. Maharaj, is not what you have achieved. It is all that we have achieved through you. Israel is here, and I've told him in the past, Israel Khan, that he opened up the practice for us to really be ourselves as advocates. Anand is here, one of the most generous souls that you will find. And Anand, if you just permit me, this is a gentleman who is not truly understood. When we were in cabinet, when we were busy with work, with everything else, Anand, brilliant as he was, you know what he realized? That many of the drivers for ministers were not being fed. And he made arrangements in the parliament and at cabinet to ensure that those persons were looked after. But today is about Ramesh Lawrence Maharaj. And I remember as a child, my first memories, not even knowing what a true lawyer was, that name resonated in our house, in our homes. But when I realized I wanted to be a lawyer, I wanted to be like Ramesh, the man himself. And I'm going to be as quick as I can. But there's so much I could say, but I will not. Except to share with you some of these things. I had learned from the great Ashford Sinanansa that as a young lawyer, whenever you're in court and you see a more senior lawyer, whether they known or unknown to you, but if you know that they're senior to you, do all you can to assist. Unless you know these things, the old school, that I don't believe they teach it anymore. And there I was sent, I'd just been called to the bar at the Shibonis Magistrates Court. I had gone to do a bail application. And I was speechless when Ramesh walked in. As Syra reflected, when he walked in, the mood changes. Everybody goes silent. Your spine is stiffened. There's a bristle. What? Ramesh, what did he come to do? Well, he was representing a fellow by the name of Maniku. Right? I don't know, you may not recall, sir. You too had come to make a bail application for the brothers. I forgot their names now, but I remember Maniku. So there I was as a young lawyer. This hero of mine is in the same room that I was in, and he is there making a submission on bail, and I had to follow. That wasn't the real thing. So I took notes for him. Every word he uttered, not necessarily for my benefit alone, but really for posterity. When he walked out, I said, "Sir, I'd like to give this to you." He said, "What is that?" I said, "I took notes for you." He said, "Put your number on it." I did. And I remember this Sunday evening, phone rings, no cell phone in those days, answer it, Ramesh Maharaj here. I was beyond myself. He said, "What you doing tomorrow?" I said, "Sir, anything you want me to do." He said, "I'm doing a rape trial in Court of Justice. I'm picking you up in the morning." And that was the beginning. I could not believe my good luck that I could get to actually sit in this car, to go to court with Ramesh Maharaj and hear my name attached to a case that he was involved in. Many trials after, many trials after, this man remains a hero to me and for the young who do not know. He went through a crucible of the worst attacks that one could face and came out like a true diamond, a precious gem for us all. Mr. Maharaj, Lynette spoke about what you've done in terms of the administrative and public law and constitutional law. So I shan't repeat those things. What I will tell you is that I had the opportunity to work with this man in many cases. And the highest level of integrity, honesty, and decency is what he imbued in me and for all of the juniors who've worked with him over the many years. Till this day, the respect I have for him, I have not been able to call him by his first name. It's always Mr. Maharaj. And as I, making my plans to depart, not necessarily life, but a different transition, I had to reflect that what one does between the two most important days, your birth and the other one. How many could have achieved what you have done? You have been a living example, not just to lawyers, but to a country. To the lawyers, yes, that you could take on any challenge. And I tell young lawyers, and in particular those who come close looking for work, I said, listen, this is not a work. This is a profession, this is a calling. And it is not a bureau d'échange, meaning that it's not for to pay me money and I give you a service. It is much more. And Mr. Maharaj stood as an exemplar for all the years. There was never a cause that came to him that he refused to participate and to help. To the young lawyers in particular, this is a man, whatever difficulties you have, professional or otherwise, Ramesh, I just did it for the first time in 40 years. I'm actually able to pronounce your name, not Mr. Maharaj. I'm going to give myself a round of applause because I have not been able to do this for 40 years. And the reason I think I'm able to do it is because today is not just the lawyer we are recognizing, but a human being who took a small space as one man, but expanded out your influence throughout the length and breadth of this globe. The many authorities that your name is attached to either as a litigant or as an advocate have changed jurisprudence in many, many countries. So, Mr. Maharaj, you know I've always considered you like a guru, and you are. What I want to share with you is that I don't want to say it's a dying breed, but it's a less and less common feature for young lawyers to have the opportunity to integrate, to speak with, to communicate, to have the cover of experienced counsel. That is so important that I can tell you personally, I was a bit of a badass young lawyer. Meaning that I would behave in a way, because I learned from Ramesh, that if, not bad manners, no. I learned from him that you do not allow a client to pay the price for your courtesy for persons who have authority and who are exercising it not with justice in mind. And of course, you'll be very good in court, and if you take us down a line and you cross the line, in my view, where the client is being oppressed or not properly being given justice, then they change your tone. And I had the confidence that whatever trouble I could get in, oh God boss, Ramesh is there. And if you look back, not just in the recent past, but for the longer past, any lawyer, anybody in trouble, this is one man who will stand with you. And the young people like to say the light up things. Let me tell you what he taught me 30 odd years ago. He said, if there is danger coming, and there was a lot of that in our society, many have forgotten this, the political persecutions and all the awful things that forces, dark as they were, attempted to put their claws on our citizens, and he stood, and many of us still do. So when that is happening, put a light on it. Mr. Maharaj, thank you for being a light to us all. God bless you.
Distinguished judges, former judges, friends, and of course the guest of honor, Mr. Ramesh Lawrence Maharaj, Senior Counsel, himself. It was on a fateful day, a Sunday I remember, when I had the privilege of first speaking with Senior Counsel. I had made an application to a rather miscellaneous looking advertisement placed in the newspaper on the cover of a post office box number. The name of the firm advertising was not given in the ad. It was just a post office box number. And I made an application. At the time, coming out of a rather challenging and penurious background, I was wondering, where will I get a job? Who would employ me when I left law school? The advertisement had come out before there was the call to the bar. And I sent out several applications, one of which concerned this particular post office box number. And in those days, I recall, on either Radio 610 or 730, there was a program which dealt with the hit parade. So after listening to the hit parade and the top 10 songs in the country at that time, I received a call on a landline. There were no cell phones at that time. And the person on the other end asked me if I had placed an ad to work with him. I didn't know who I was speaking to. He identified himself. And of course, I was in shock. He told me he had placed the ad. And I was to come for an interview. At that time, his office was on Harris Street, just in rather close proximity to Ali's Doubles. Over the road resided one Farouk Hussein. And I remember Senior's offices on the top floor. He also had offices on the bottom floor. And I remember actually being in a position to share a telephone with the dearly departed Basdev Pandey. Owing to seniors' efforts, and of course at that time, let me tell you, Ramesh Maharaj was a fabled attorney in this country in the early 90s, the 80s, etc. Fabled. He had a very storied career up until that point. And one of the galvanizing factors in that storied career would have been the interplay between senior and a certain trial judge who carried the name Maharaj. And coming out of that interplay, Ramesh Maharaj, by dint of his steadfastness, proved to be irrepressible, he proved to be defiant, and he gave persons at the time hope and courage so as to be able to push back against several forces at the time which perhaps were going in an unfavorable direction. Suffice it to say that my time spent in Mr. Maharaj's employ also furnished me the opportunity to rub shoulders and more poignantly to learn from persons such as the late senior's wife, Ms. Maharaj S.C., very incisive legal thinker, very businesslike. Even to interact with her, you had to summon up some courage. She was very, very to the point and extremely nimble of thought. I also had the opportunity to rub shoulders and to learn from the late Wendell Kangaloo, who at the time was outstanding and who at the time was extremely nurturing. But he was nurturing in a tough love way. He wouldn't baby feed, spoon feed you. He would drop hints. He would check up on you. And again, I was fortunate enough to be able to be put in a position to learn from Wendell Kangaloo. There's an elderly gentleman who was at the time who seemed to be the Bible of conveyancing by the name of Mr. Chedi, Dalton Chedi, who also spent considerable time with me. He would explain, when you had difficulties in conveyancing, Mr. Chedi made everything seem so easy. He was elderly at the time, but again, with a very, very keen mind. So here I was, out of the blue, I would say, being given the opportunity to flourish and to learn in this particular chambers. And Mr. Maharaj, senior counsel, was a very, very tough boss. He was a stickler for punctuality. And if nothing else, he always stressed the need for preparation, the need for voracious research. At the time and shortly after, the chambers moved from Harris Street to Irving Street in San Fernando. Seniors' library was a thing of beauty if you loved reading. And he was always a person who was minded to push the envelope. This senior counsel was never inclined to be a standard bearer for the status quo. He was always minded to try new things and to push the law into areas, big novel areas, I would say. It is as a result of my interaction with Mr. Maharaj, senior counsel, that I was introduced at the time because he had a varied practice to the industrial court. I remember his interest in workmen compensation. I remember his interest in the criminal law, the civil law. I remember in a particular case, the case was the case of Trisha Motilal, a young lady who had received serious injuries as a result of a motor vehicle accident, and out of which she would have become a tetraplegic. At the time, that was the first time I was hearing that word. I remember having to look it up. But she had no movement below her neck. And seniors' support and urgings would have resulted in the court awarding at the time the highest award by way of damages to the family of Trisha Motilal. I heard Prakash Ramada speak about Manikou. Well, it was through Mr. Maharaj and the interaction I would have had with him, senior counsel, that I too can speak a bit about Manikou. But I won't regale you with stories about Manikou, except to say, Prakash didn't remember his name. But his name was Sham Ramlochan. And his brothers were Mohan Ramlochan and Premnath Ramlochan from El Socorro. Those were the siblings of Manikou. So I just going to turn it over for you. Mr. Maharaj, I was having a conversation with Mr. Ramada a short while ago, during which I would have intimated to him that far too often we only pay homage and tribute to persons who would have played meaningful roles in our lives after they pass on. This luncheon and this event has provided all of us with a platform from which we can indicate to you, tell you, I wanted you to hear me say it. I didn't want to say it if you were in another place. I wanted to be in the same place with you when I said it. On behalf of my family, a boy coming from Bertrand Street in San Fernando, just off Coffee Street, I want to thank you for taking a chance with me. Thank you very much.
Ramesh Lawrence Maharaj dates back to when I graduated from law school. And I too, like the former speaker, Mr. Roger Gaspard, was starry-eyed, full of hope, with a neat stock of fixed opinions and dreams. And I had done well at the LLB. I graduated with best all-round student and all of that. And I went to an interview at a law firm in Port of Spain. And I didn't get the job. And I remember getting a call from someone by the name of David Young, who explained to me that I had done well in the interview, but I was not the right fit for that particular firm. Soon after that, in the midst of a bout of debilitating depression, having come from a family of 18 children and being number 16 and the first one to have completed a secondary education, the weight of expectation was upon my shoulders. And I too responded to a similar ad like Mr. Gaspard. A very nondescript, innocuous ad that could easily be today placed by personal escort services. But I responded. I didn't say that from experience. I responded to the ad, and I got a phone call from Mrs. Lynette Maharaj, the late Lynette Maharaj, and I went there. I got a glimpse of Ramesh standing next to the calendar with Sai Baba. And I was interviewed and given my first job. Ramesh had just become Attorney General And Lynette said, we need someone to help us out here. And I think he gave her the green light, so I was hired. I got 6 boxes. She said, I said, this is all Mr. Maharaj work. She said, no, that is one file. She said, that's one file. I said, oh. She said, well, you have to be in the Court of Appeal. So I was telling Mr. Maharaj, that was the famous case of Barlow Rampasad versus Republic Bank Limited. A gentleman, an elderly gentleman who had a stroke, and the bank was trying to repossess his property because he could not work and pay his mortgage because he had a stroke. Ramesh took on that case, and he was able to get an injunction, get a stay, and he was basically buying the man time. Suffice it to say, we won the appeal. Sat Sharma was the Chief Justice in the chair, and they took a very compassionate approach to a very important point that I picked up. But in going through those 6 boxes, I saw the measure of the man. Who on earth in the right mind will take on a stroke victim who can't even pay the blasted mortgage for a client? How we going to pay his legal fees? Now I was thinking about that because I wanted to know if I could charge. And I said, well, if he ain't got no money, what will he from me? And in them days, I go in 4 o'clock by San Fernando by the wharf to take a bus to go to town because I had no vehicle. So, as things turned out, we won that matter, and I interacted through Mrs. Maharaj with Mr. Maharaj. And I fast developed a voracious appetite for reading all your cases. Typewritten judgments, cycle style judgments. We have Justice Lucky, and we have many other great distinguished judges. But I share and echo the sentiments of the previous speakers. You will want to push the envelope and push the boundary. The colorful roller coaster ride of your life has led to you being a lawyer, a claimant, a legislator, an attorney general, a politician, and even a defendant. All extraordinary caps to wear, sir. I have had the good fortune, having read those cases, to see the points that were before their time. The points that you took that judges rejected as meaningless and misconceived. I built on those cases. I stand, as many of us do in this room, on the strength of your shoulders. It was in the case of Harder Sinanan, which is in the Western Law reports, that Mr. Maharaj first challenged the offense of murder being non-bailable. And the Court of Appeal rejected those arguments. Today, many years, almost 2 decades later, I remember that judgment and finally fulfilled the intellectual quest of Inakili Charles and the Attorney General, and the Privy Council held that murder cannot be a non-bailable offense because it violates separation of powers. An argument that was first run by Mr. Maharaj 20 years before. It was in the case of Mr. Maharaj, remind me, before Sumir Bansraj, when you couldn't injunct the state, that Mr. Maharaj got around it by getting the Court of Appeal to come up with the term conservatory order. 25 years later, I appeared before the Honorable Mr. Justice of Appeal Peter Jamada, and in the case of Sasha C. Prasad and the Attorney General, we were able to overrule that. And again, it was on the basis of the arguments that were rejected in that case that you did in Bansraj. I say these things merely to show that a leader is a man whose ideas and thoughts are sometimes too far and way before their time for others to think of. And many a judge in our country has fallen victim to being trapped into the vortex of the time that they were in without the ability to think outside the box. Mr. Maharaj was one of the few who had the ability to think outside the box and to have legal creativity in his thinking process. Your legacy will live on because the 2 pieces of legislation that you passed as Attorney General, the Freedom of Information Act and the Judicial Review Act, will forever remain transformative revolutionary laws that has transformed the concepts of transparency, accountability, and good governance in this country. Mr. Maharaj, we share one thing in common, along with, I was just reminded, Justice Peter Jamada, Wendell Kangaloo, and all of the great names, and that is we all had a common legal guru and mentor. I pause with Mr. Maharaj's permission to pay tribute to the late, great Sir Fenton Ramsahoy, without whom the creative inspiration would not have been possible in our careers. Today, when I look at this crowd, and I go to Law Association events, Ms. Sweet, the crowd here is overwhelmingly South-based. To celebrate a man who is a national icon, there's a disproportionate absence of persons from after the lighthouse. It is the reverse. The reverse is true if we had this function to honor someone from north of the lighthouse, because the crowd would be disproportionately from south, notwithstanding the fact. The fact that we're able to make that journey from south to Port of Spain to celebrate national icons past the lighthouse, and the lack of reciprocity, I want to make special mention of it, because Ramesh Lawrence Maharaj is a national institution and legend. I make that point not as a mere observation, but I make the point because Mr. Maharaj represented and continues to represent something for us in South Trinidad. There was a natural inferiority complex. Perhaps there still is. And in that mold, when we appear in court, certainly for myself, when I appeared in court and I came up against my colleagues who were from North, their level of familiarity, their level of confidence, and their level of the consummate ease with which they were able to stand in court, because they interacted in the same social circles on the golf course in Port of Spain and so on, put me at a psychological disadvantage. I sought sanctuary and refuge in the person and the footsteps of persons like Fenton Ramsahoy and Ramesh Lawrence Maharaj, because I felt a sense of immense and intense pride, being a Southerner, to see him come up against the likes of Frank Solomon, Carl Hudson Phillips, Bruce Prokop, and all of the great names, but standing shoulder to shoulder and demanding equal respect and demanding equal level of courtesy from the court. That gave many of us, Mr. Maharaj, in South, it gave us not the right to dream, but the right to achieve. For that, sir, I thank you personally, and on behalf of all of the young lawyers in my generation who looked and stared deeply into the footsteps and the imprints of your footsteps so that we could follow and be the lawyers that we are today. I thank you.
Lord Chief Justice, all protocols have been duly observed, but in keeping with the well-established convention, I hereby recognize and acknowledge the presence of the distinguished attorney at law, Ramesh Lawrence Maharaj, Senior Counsel, who the Assembly of Southern Lawyers is honoring as he enters his 60th year in legal practice. It is beyond all reasonable doubt that Ramesh Lawrence Maharaj, Senior Counsel, has earned the envious distinction to be branded the greatest criminal advocate ever to emerge in Trinidad and Tobago. Many of his contemporaries in the legal profession believe he is simply the greatest advocate in that he mastered both the criminal and civil branches of law in his practice. Be that as it may, I dare say his status as such be it criminal or both criminal and civil, will never be surpassed by present or future attorneys in this country. And it is a record that will remain intact forever. From his early years in his practice of law, Ramesh represented his clients to the best of his ability, forcefully and fairly. He will fight hard for his clients, which included criticizing presiding judges. In a small jurisdiction of Trinidad and Tobago, his professional persona was well known amongst judges, fellow practitioners, the general public. But Ramesh, at the age of 30 and less than 10 years in practice, was no extraordinary, brilliant, or potentially great attorney when he appeared in a civil matter on the 17th of April 1975 in a mundane civil proceeding in a San Fernando High Court, in which he was sentenced to 7 years simple imprisonment for contempt of court. And it was this fight to remove that conviction and sentence that catapulted him into the Caribbean jurisdiction and possibly the entire English Commonwealth jurisdiction as a potentially great advocate. Thus, on April 17, 1975, Ramesh became the first barrister in the English-speaking world since 1607 to be imprisoned for contempt of court for something he said to the presiding judge while actively arguing a case. He had requested the presiding judge, Justice Sunny Gulwal Maharaj, to disqualify himself from all cases in which he was counsel on the ground of unjudicial conduct by the said judge in his matters. The judge had refused applications for adjournments made by attorneys holding for Ramesh in order to accommodate him representing his clients. He dismissed the cases. On the 17th April, in his application for the judge to step down from presiding over his cases, Justice Maharaj asked Ramesh if he was saying the court was biased against him, and Ramesh just looked at him and replied, "This is not the right time or the place to answer that question. But I say to you that you are guilty of unjudicial conduct." Justice Maharaj then promptly charged Ramesh with contempt of court and sentenced him to 7 days simple imprisonment. Ramesh appealed his conviction and sentence of 7 days imprisonment all the way to the Privy Council. He won. The entire incidence of the contempt charge, his sentence of 7 days civil imprisonment, and his rightful vindication by the Privy Council are all documented in his book, Barristers Behind Bars. I urge every young attorney to read this book. This victory catapulted him into the Caribbean region as an indefatigable fighter, not only for his personal liberty, but the right to a fair trial for all accused persons whom he represented before the various courts in Trinidad and Tobago. He was carving out his career as the best criminal defense advocate in the country, if not the entire Caribbean. He kept on winning cases after cases at the magistrate court throughout the country, at the Sides Court in San Fernando, Port of Spain, and the Court of Appeal. The West Indian reports attest to his victories in the Court of Appeal. He was unstoppable in his quest for justice for all. This caused an unscrupulous group of police, headed by a certain high-ranking officer, one senior superintendent Hubert Williams, now deceased, to hatch a diabolical plot to bring Ramesh to his knees. He was winning too many cases instituted by the police. He was falsely charged together with another attorney, Mohan Sagwa, for promoting the cause of public justice. He won that case, but a few years later on, he was charged with a serious offense of conspiracy to murder. A totally false charge with a convicted reprobate as a witness against him. He again once more won in the court. And incidentally, poetic justice caught up with Hubert Williams in a few years after all the false cases were dismissed. Hubert Williams was sentenced for conviction for unlawful killing by shooting a citizen to death, and he was sentenced to 7 years hard labor imprisonment. I remember that case very well because it was Justice Locke who presided in the matter. Within a few years of his vindication of the contempt charge by the Privy Council, Ramesh was a household name throughout the entire English Commonwealth jurisdictions. He was the first advocate attorney to raise important constitutional issues as part of the defense in criminal matters, and very often filed collateral constitutional motion on such matters and won. These victories impacted on the defense of accused person at the criminal assize court. Ramesh's skill as an advocate was simply fantastic. The use of his voice, his meticulous cross-examination of witnesses, addresses to jurors, and general modus operandi of his advocacy were mesmerizing. Students from the Hugh Wooden Law School, young lawyers, police officers, and members of the public will pack the assize court with Ramesh Lawrence Maharaj, senior counsel, was the advocate attorney for the accused. I myself, as a young lawyer, was an avid admirer of this great defense attorney, and I took every opportunity to attend his trials in order to learn the skills he would display in his advocacy. It was a learning experience to witness his body language in a court of law. How he enters the courtroom, how he talks, looks, moves, gestures, sits and stands. His facial expressions and the use of his voice as he makes legal submission. All his actions in court demonstrated professionalism, manners, dignity, and confidence. He was always cordial and pleasant with his colleagues and very accommodating with legal advice to young attorneys. With his style of advocacy, Ramesh brought respect and admiration for criminal law advocates in Trinidad and Tobago. Traditionally, criminal law advocates were the stepchildren of the legal profession. We were scorned by our colleagues who were practitioners at the civil bar. We were the he say, she say, them say, they say lawyers. Just talk and talk, devoid of true knowledge of the law with no finesse in the conduct of cases in a court of law. Ramesh gave us the courage and strength to stand our ground as flamboyant advocates, so much so that law students were then advised and now advised to study the art of the modus operandi of cross-examination by criminal law advocates and not the civil law advocates. Because by our practice, we had mastered the fine art of cross-examination. I hazard a guess that Ramesh, at this present time of his career, must have defended more than 500 accused persons charged with murder. And his victories in those cases can be safely put at 95 to 99%. And based on his merit, his ability, and his integrity, Ramesh acquired unprecedented wealth as an attorney in representing clients charged with criminal offenses. What he gave back to the society, an impoverished person charged with serious criminal offenses via his human rights organization. He represented hundreds of impoverished persons pro bono, thus forgoing millions of dollars. He is a true and dedicated advocate at the criminal bar, and I salute him. Ramesh Maharaj, Lawrence Maharaj, AG of Trinidad and Tobago. Ramesh had a short stint in the national politics of the country. He was appointed Attorney General by Basil Pandey in 1996. In his capacity as AG, he informed Pandey there was massive corruption taking place in the construction of new international airport, Piako Airport. He was rebuffed by Pandey with a question, where is the evidence of corruption? AG Ramesh Lawrence Maharaj, Senior Counsel, hired an expert fraud investigator, one linguist, to investigate the matter and obtain the evidence, if any. Ramesh took the evidence to Prime Minister Basil Pandey, and in turn, Ramesh was removed from the cabinet. Ramesh, together with other ministers, then brought the entire government of Basil Pandey to its knees. Pandey will lose the next general election, he called, and thereafter never return to government. You simply do not rebuff an Attorney General like Ramesh Lawrence Maharaj with where is the evidence when he complains to the Prime Minister of corruption in his government. Fast forward to his latest national victory at the Privy Council. The Victoria Caesar's matter judgment inferentially indicated that Chief Justice Ivor Archie had lied on oath and thus committed perjury when he swore that he never forced Justice Caesar Ayres to resign, nor did he trick her in resignation, resigning her position as a High Court judge. He committed the criminal offense of misbehavior in public office, which carries a term of imprisonment, usually up to 15 years with hard labor. 3 days after that Privy Council judgment, I protested on the Hall of Justice step with a placard which read, Justice Archie, Ivor Archie, you are a disgrace to the judiciary, resign now. CJ Archie refused to resign then. Ramesh Lawrence Maharaj, Senior Counsel, gave an interview via the printed media. He explained the ramification of the Caesar Ayres matter and stated that he cannot comprehend how Chief Justice Archie could remain as Chief Justice after the judgment in Caesar Ayres matter. A few months after Ramesh's comment, CJ Archie stunned the entire nation by resigning as Chief Justice. It is my understanding that the political directorate was about to trigger a Section 137 tribunal in order to ascertain whether on account of the Caesar Ayres matter, Ivor Archie should be removed as Chief Justice of Trinidad and Tobago. You simply do not toy with the great Ramesh Lawrence Maharaj, Senior Counsel. Ask Basil Pandey and Ivor Archie. On behalf of the Criminal Bar Association and my good self, I salute and toast the distinguished and greatest criminal attorney, Ramesh Lawrence of Arabia, Senior Counsel, ever to emerge in Trinidad and Tobago, who is entering his 60th year in legal practice, a milestone as it is remarkable and testament to the lifetime of dedication to the law and the legal profession in Trinidad and Tobago. Your legacy will live on forever. It will never be surpassed. Thank you.
Senior lawyers, Mr. Maharaj himself, learned counsel. So, Mr. Jagru, I have to start off with a small reprimand. Next time, call me to talk first, please. Because it is real pressure coming after Mr. Ramada, Mr. Gaspard, Mr. Ram Logan, and Mr. Cal. I feel like if I'm in court having heard submissions from lawyers, and then I have to come here and give an oral judgment incorporating what they have all said. So here goes with my extempore oral judgment. I did not have the privilege, as these other gentlemen, to have worked with Mr. Maharaj. But what I could see is that from the very beginning, before I started law, I didn't have any family in law. I knew the name Ramesh Lawrence Maharaj. So when I had the opportunity to hang out in the chambers of Mr. Hendrickson Sunas as a law student, whenever cases were being heard, I would run up to the court to listen. And it was there that I had the good fortune of listening to Mr. Maharaj make submissions in a constitutional case before Justice D.L. Singh in one of the Karani matters. And I would go and listen during the day, and then in the criminal court, I would go across and see him cross-examining police officers, and you know the cross-examination with the station diaries, and all of the things which were not in the station diaries that the police were saying took place. So I was exposed to his genius as a lawyer, his hard work, his scholarship, the manner in which he conducted his cases, his presence in court, his dignity, and then you saw all of the qualities of a great advocate coming together. I then came into practice and I worked in a firm in Port of Spain, and one of the cases we had, you might recall it, it was for the other side and we were for one of the companies in Point Lisas. And I had the opportunity of seeing Mr. Maharaj as a lawyer on the other side. I was, of course, the most junior of the lot, photocopying and but it was seeing him make his submissions in court and standing up. And the advocates on our side were relentless, but he never lost courage and he fought that case to the very end. I then encountered him when I went to work in the DPP's office, and we were on Sackville Street, and he came one day. He was the Attorney General then, and DPP lawyers were underpaid. Mr. Gaspar, I'm sure you'll say this, you still are underpaid, but they were underpaid, we were underpaid, under-resourced, and every word you could get. And he came and met with us in the library, and he was an Attorney General, new Attorney General, and well, we went and the seniors spoke up and so on and said, well, we don't have books, and well, there's a salary issue and resources and space and so on. And I can tell you that weeks after that meeting, after not getting books for years and years, every lawyer who went to court got a new copy of the Archbold, because Mr. Maharaj went back and ensured that we got it. And we then got the largest increase in salary that we had ever had in the DPP's office after that. And I'm told that he went to his colleagues and they said, well, you know, we can't afford that now. And he found a way to give us this through an allowance. And then a little while after that, we got a different building, larger building, which would accommodate more people and so on. It was the same thing in South as well. We had an office on the promenade, and then we moved to better accommodations and so on. And then, as a judge, I've seen Mr. Maharaj making submissions. And it is the quality of the submission. It is his integrity. You know that he comes with thorough research. You can rely on what he presents to you. He gives you all of the cases, bundles and bundles. Mr. Ramlogan spoke about the boxes. We get the volumes and volumes of the cases. And you know that when he has presented a case before you, every stone has been overturned to ensure that he gives the best possible assistance to the judges. After that, if we get it wrong, well then we get it wrong. But it is not because of the assistance that is provided by counsel. He's an absolute example to all silk in this country. He's an example to all junior lawyers. And I'm I'm really happy today to see so many young lawyers here, because a lot of them don't know the stories. They don't know but today they got a small inkling of those stories about Mr. Maharaj and his contribution to the profession. And as we were sitting there, I was encouraging him that he needs to write his memoirs so that we have it as part of the legacy for our profession. So, on my own behalf and on behalf of my colleague judges who are here and members of the judiciary, I wish to thank him for his 60 years of service to our country and to the profession of the Commonwealth, because he's a name known all over, if only because of barrister behind bars and the cases which arose, but it's an example of courage. And just today I was reading about a King's Counsel who is under pressure in the States because the judge wants to cite him for contempt for a speech that he's giving to the jury. So I'm sure your case is going to feature prominently in that matter. But we thank you and we pay tribute to you and we wish you many, many, many years before us. I know you're not going to give it up this easy, so that we can look forward to seeing you for many years in the court, given the kind of quality assistance that we have come to expect. And we wish you great health and camaraderie. All the best, Ms. Maharaj. Thank you very much.
With your leave, just offer some personal observations, because there's so many. Unlike Mr. Gaspar and probably Anand, I didn't apply by P.O. Box. I heard Ramesh was an Anglophile, and my English accent was even broader then than it is now. And I applied, and Lynette was there, but Ramesh was there, and they took me. And that was 30-something years ago. And I'm very grateful for that opportunity. Sarah has spoken about Ramesh's work ethic. It is extraordinary. Juniors can speak to that, but I can speak to that. In a time when we didn't have cell phones, my phone started ringing from 4 a.m. continuously. It happened and continued for many months, when I then took the incredible step of asking TSTT to remove my landline. And they did for several months. Ramesh found it odd that he could not speak with me. I never told him why. I told him that. She said, don't tell Ramesh. He admitted me to practice in the morning. This is about 34 years ago. And in the afternoon, we came back and we had a matter going on before Justice Anthony Lucky. You may recall it, Ramesh, the Jabbar case, the Nariva swamp, where our clients were planting rice in the swamp. Happily, Justice Lucky got it right, and our client was denied the opportunity to continue planting rice in the Nariva swamp. That afternoon, after I was admitted, we came back to San Fernando, and Ramesh continued his cross-examination of the then Minister of Agriculture in that Jabbar matter, who happens now was, in fact, and subsequently, our Prime Minister, Rauli. And Ramesh, quite uniquely, has sued Rauli many times in his capacity as head of the cabinet, and also is acted for him personally in a matter involving the Tobago Islands. I also have very fond recollections of our time together, but perhaps what really speaks to me is how controversial Ramesh is. We've spoken about it. In terms of his imprisonment, 7 days simple imprisonment, I don't know if many of you have read or had the opportunity to read Marcel Berlin's book, Barrister Behind Bars. It's sadly out of print, and I hold on very dearly my copy. Marcel Berlin's, in fact, was the author of The Law Machine, highly regarded author. And he speaks at page 51 of not only of Ramesh's trial, but he says that on the day that he was released from prison after serving 6 days, that afternoon, Ramesh attended a public lecture that was being held by the Chief Justice of Nigeria, and in attendance was Sir Isaac Hayatali, our Chief Justice at the time. And Ramesh was there, and in one of perhaps the most glorious cynicisms there is, the title of that lecture was "The Rule of Law and the Right to a Fair Trial." And Berlin's thought that in the capacity of which Ramesh attended, hours after leaving and being there, it was a glorious irony, if only because Sunny Maharaj was also there, Justice Sunny Maharaj, who in fact imprisoned Ramesh. I would have loved to have been a fly on the wall at that event. But there was also controversy in 1999. Some of you may have been present at the opening of the law term when the then Chief Justice Delabastide launched a stinging attack on two persons, Ramesh, who was at that time Attorney General, and Carl Hudson Phillips, who at the time Senior Queen's Counsel, who at the time was President of the Law Association. And the subject of that was the fact that Ramesh, through the Attorney General's chambers, was seeking public accountability for the money spent by the judiciary. And of course, Chief Justice took that as a personal attack and a personal affront. And I think in 2011, Delabastide wrote in his memoirs, in chapter 11, he devoted an entire chapter to that and made certain statements. Ramesh, we are awaiting those memoirs because we need to respond to that complaint. We've all heard of the various, not just controversies, but his contributions. I think it is time now to hear from the man himself. So ladies and gentlemen, I'm sure that you will join with me, and on behalf of the Assembly of Southern Lawyers, from hearing from the person who we are paying tribute to, Mr. Ramesh Lawrence Moore.
The Honorable Chief Justice and all protocol observed, I would first like to thank the President and members of the Assembly of Southern Lawyers in having this function and program to honor my contribution to the law. I just want to make one amendment. I am 59 years and 8 months in the practice of law. So I still have 4 months to go. When I received this invitation, I wondered whether the President and the ASL was sending a message to me. Ramesh, it is time for you to retire. Well, I want to tell the ASL and its president that retirement is not on my agenda. I have batted a long inning in the law, and I intend to bat like Brian Lara and break all records. I want to say, however, that I could not have achieved what I have achieved in the law without my dear wife, Lynette Maharaj, Senior Counsel. She played a vital role in my success as a lawyer. I also want to thank all the lawyers who have worked with me, some of them who are here and who have appeared with me in cases during the almost 60 years journey in the law. I have no doubt that my present team of lawyers at my law firm, RLM & Co., headed by Ms. Vijaya Maharaj, would facilitate me to break the records I spoke about. I want to share with the audience, because I know there are young lawyers in the audience, I want to share with the audience some of the experiences I had in the practice of law. The purpose of that is probably to show that how one can benefit from what other persons experience in the law. I studied law in England. In those days, one could not have become a lawyer by studying law in Trinidad and Tobago. I studied law in England, and at the law course in London, I had the opportunity of seeing and reading the origin of the legal profession, what the duties of a lawyer are, and basically what are the challenges that lawyers can face and how they should deal with them. And one of the things which has stood and stuck in my mind was that lawyers have a duty to be independent and fearless in the discharge of their duties. And lawyers have a duty to protect the independence of the judiciary and the rule of law. And lawyers have a duty to make governments account to the public and to the law. And those things have stuck in my mind as a law student. When I returned to Trinidad to practice law, I could not get into the civil law practice. Any office that I went to on the Harris Promenade, they had no vacancy, they were filled. And the work in the civil practice in those days depended upon solicitors. So no matter how you try to get a civil case in the High Court, you couldn't get it. So I opened up chambers separately, and then I started to do magistrates' court work and then criminal cases in the High Court. And I want to say that Israel is correct. I had a very extensive practice before judge and jury. And I can't check how many criminal cases I did, but it would have been hundreds of criminal cases. And I was very successful before juries because in those days, the juries were persons who witnessed the police brutality in the villages. So therefore, when you had most of the cases at that time based on confessions, effective cross-examination of the police officers with the jury listening would in effect mean that they would have doubts about the guilt of the accused. And it is in that setting I practiced criminal law. I did a lot of criminal cases, but I really wanted to do civil law. But I got a break to do civil law when Justice Ralph Narayan, when he became a judge, when Ralph Narayan became a judge, and when a lawyer called Pat Thorne immigrated. So I got all their cases to handle. And in the 1970s, with all those cases, I started to appear in the High Court. And Sonny Maharaj, who was a very good friend of mine at the bar, I do not know why he took the position that I should be in the court all the time, even though I had so many other cases. And other lawyers were getting their cases adjourned. I was in Port of Spain arguing a case with Dr. Ramsoy, the SES case, and he dismissed some of my cases. And I went before the court, and it may be a young lawyer in those days, I probably could have said on judicial in a better way, but I said on judicial conduct, and he charged me for contempt. And I remembered in London that I was shown a lawyer, what's his name? Sir Thomas Erskine, who stood up for the independence of lawyers. And my position was that I am not going to apologize. So when I reached the police station, my friend Basi Pandey came, and several lawyers, they said they had spoken to the judge, and the judge was prepared to rescind the order. I said, go back and tell the judge that if I come back before him, I'm going to ask him for 14 days. They said, that is not a very good idea. When the jeep took me to Port of Spain, and I entered the prison, I saw a lot of people outside the prison. Well, I started to wave. Then I had a visit from Mr. Michael Elabastide, because he was then the president of the bar, I think. And he came to me and he said, you know, because I used to be junior to Michael for in some of the cases, he said, Ramesh, you know, I could go to Sir Ellis and I could arrange a pardon for you if you would apologize. I said, Michael, I cannot apologize. I have to stand up for the independence and the fairness of the legal profession. He said, you're going to spend 7 days here? I said, yes. Carl Hudson Phillips came to me and he said that he spoke to the Chief Justice, or the Chief Justice spoke to him, and that if I went before the Court of Appeal, the order would be rescinded. But in fairness to Carl, Carl said, Ramesh, I am not telling you to do that. I am just the messenger. I said, go back and tell the Honorable Chief Justice, thanks very much, but I'm not apologizing. So they had another hearing, and then the judge, Justice Scott, sent me back to the prison after one judge had granted me bail. And I decided that I was going to fight for the independence and fearlessness of the legal profession. I must say that it might have been very difficult for me to have done that if my wife did not agree with me. So when my wife came and she saw me, and I told her what my plan was, I said, but I will have to consider if you tell me I shouldn't do this. She said, Ramesh, if you apologize, I'm going to leave you. So that is the story of Barrister Behind Bars. And then Marcel Berlins from the London Times rang me and said he wanted to come to Trinidad to do this book. And he did that book. And I suppose that is what happened. And it's now a case in which not only the contempt, but then came the question as to what will happen for the compensation. So Fenton Ramsahoy was my legal advisor because I think at that time he had left the law school, and he appeared for me, and we had this constitutional motion, and the concept of the constitutional motion was, because as you know, you could not sue a judge for damages except you could prove malice and etc. So our case was that Justice Sonny Maharaj was part of the judicial arm of the state, and the state was responsible for the violation by the judicial arm of the state of the fundamental right. So we went to the court on that basis for damages against the state for the judicial violation of the fundamental right of Ramesh. We went to the High Court. The High Court dismissed the claim, said it was a frivolous claim. Went to the Court of Appeal. There was a majority judgment, but Justice of Appeal Clement Phillips gave a dissenting judgment. Anyhow, went to the Privy Council. So now I heard that Lord Diplock was a very establishment judge, and he was the senior law lord. So I was totally afraid as to what is going to happen with this Privy Council case. But I heard that Lord Diplock was delivering a speech in Scotland at the Commonwealth Bar Association. So my wife and I went to attend that conference because I wanted to listen to his speech, because the topic was the development of law in the Commonwealth. And when I heard Lord Diplock said in that speech, because that was the vacation before the case was heard in the Privy Council, he said in his speech, as a judge, words to the effect, as a judge, if there is no law and there is injustice, I would develop the law. So I felt he was talking about my case. But my wife told me, no, he's talking about cases generally. Anyhow, went to the Privy Council when this case was being heard. And when Turner Samuels, my lawyer, got up to start his submission, Lord Diplock said, Mr. Turner Samuels, could you tell me what is the meaning of the word redress? So it seems to me that Lord Diplock had made up his mind before he even heard the case because he would have read the papers. Anyhow, to cut a long story short, the Privy Council decided with one dissenting judgment that it was a violation by the state, by the judicial arm of the state, and that I was entitled to monetary compensation. Now, I want lawyers generally that in my education as a lawyer, I saw how the law was developed by judges. I saw the common law, equitable principles, the land law. Even without the input of Parliament, the judges developed the law. It occurred to me that for judges to develop the law, the lawyers appeared in the cases. So if the lawyers can do some of the work for the judges, then you can move the law forward. So with that in mind, when I started to practice civil law, that is what I had in mind. I felt that I could cause a judge to develop the law if I do research in the law and if I present submissions that will encourage a judge to develop the law. So a cane farmer came to me in 1975, Ramesh L. He said he was a cane farmer, but when he supplied his canes to Carney Limited, they were deducting monies, and those monies were going to an association, the Trinidad Island Wine Cane Farmers Association. But he was not a member of the association, but was deducting monies as a cess. So I took up the case because I said that is a breach of the fundamental right to association and to property. And Ramesh L. versus the Attorney General argued the case before Justice Braffett, and he declared the law unconstitutional. And I was told that was the first time in the Caribbean a law or a section of a law was declared unconstitutional. I do not know how correct is that. The state appealed. Dr. Ramsay argued the appeal with me, and it is part of the law reports now of Trinidad and Tobago and of the Caribbean. So that is what I believed in when I had to be confronted with several facts of cases in which there was already no precedent. And I can think of many, and you would have heard of so many cases today that we use the law in order to develop the law. For example, when the maxi taxi drivers in Port of Spain came to me, and they were given an assurance that if they moved their maxi taxis from whatever street it was, where they did not pay any fee, and they put their taxi stand in City Gate, and the government would not allow them to be under the management of the PTSC, and they would not have to pay any money. Then the government changed its mind and asked them to pay $1 per exit trip, and for the PTSC to manage them, I went to the court. I went with a judicial review claim, Papanet and the Attorney General. And my case was that that assurance and that promise given to the maxi taxi drivers created a legitimate expectation of a substantive benefit, which was established in public law. And the High Court, and I think the Court of Appeal agreed with it, went to the Privy Council, and it's the famous judgment, Papanet and the Attorney General. So I do not want to go through all some of the cases. I have a list of them here which I intended to tell you about. But as young lawyers and as lawyers, I would urge lawyers to look at existing law, which they believe and they have cases with, and depending on what the present decision is, and if you can find ways and means of developing that to persuade judges to develop the law, that is how the law is developed. But I want to talk about one case that has stuck in my mind, and as a lawyer, it it made me feel that something was wrong with the justice system in Trinidad and Tobago. Maharaj S.C, a judge, she was a lawyer in my office. When she came to me and she told me the story of what happened, I could not believe that that happened in my country. I could not believe that the Chief Justice could have forced a judge to resign. And when I asked her, well, why did you sign the letter of resignation? And this is all part of the record now. She told the truth. She said, I was a magistrate all my life. I didn't know about Section 137. And when she was cross-examined, that is what she said, and the Privy Council accepted that. But I'll tell you why it is a case which has stuck in my mind. I was now faced with a situation in which I was filing a judicial review claim against the Judicial and Legal Service Commission, alleging that the Chief Justice and Chairman of the Judicial and Legal Service Commission forced this judge to resign. And the way the case was conducted by the Judicial and Legal Service Commission meant that I would have had to cross-examine the Chief Justice of Trinidad and Tobago. And during my career, that was one of the most difficult tasks I had to do, but I know that I had to do it in the interest of my client. And that case, when I cross-examined the Chief Justice, it was during the COVID period, and it was a case done virtually. And if I cross-examined the Chief Justice, and that's the answers he gave in cross-examination assisted our case. And then when a witness, she's now a judge of the High Court, I would not call her name, but that witness spoke the truth in the witness box under cross-examination. She was then working at the Chief Justice's office. And the Court of Appeal of Trinidad and Tobago has to be commended for standing up and giving a judgment to protect the independence of the judiciary of Trinidad and Tobago. And when that case went to the Privy Council, I could have seen that the judges of the Privy Council were embarrassed that they had to do a case like this. Be that as it may, the case of Maharaj S.C is a landmark decision for the independence of the judiciary. I want to talk about one other case that I did, and that Privy Council about a week ago, an appeal. In 2011, there was a public emergency in Trinidad and Tobago. Persons were arrested, and I took the position then, as a lawyer, that a state of emergency should not be called or should not be used as a tool for fighting crime. A state of emergency is an exceptional situation. And if you have the police service functioning, the courts functioning, all the public institutions functioning, you cannot use a state of emergency, because when you create a state of emergency, you suspend the enjoyment of fundamental rights guaranteed in sections 4 and 5 of the Constitution. You give to a minister the power to detain persons for 7 days, which could then be extended. You prevent habeas corpus. You prevent a lot of judicial review remedies. So I took the position in 2011 that I will file a claim, a constitutional claim, that the state of emergency which was created was unconstitutional, and that the regulations which were made and the persons who were arrested their arrests were unlawful. The evidence in that case showed that even though they detained my 3 clients for the period they were detained for, and the allegations that they had against them, that there was a conspiracy to murder the Prime Minister, there was no evidence against them. The transcript of the police interview showed there was no evidence against them. So I argued that case that the regulations were ultra vires, and I argued the case that even if the regulations were lawful, the exercise of discretion was unlawful. That case I lost in the High Court, I lost in the Court of Appeal. Last week, before the Judicial Committee of the Privy Council, I do not know what the result would be. But what I can tell you is that the members of the board were very interested in hearing the arguments on both points. And let me just give you an idea what I argued about the state of emergency. The state of emergency on that occasion, and I think on this occasion also, was declared under Section 82C of the Constitution, which said words to the effect that if public safety, etc., you have the power to declare a state of emergency. I argued that the threshold for declaring a state of emergency had to be very high. It could not be a low threshold. It could not be a threshold that you have criminal gangs fighting criminal gangs. It could not be a threshold that police have a crime problem and they want to solve crime. You can have a crime situation in a country in which you may be able to create a state of emergency, but it must be that the police cannot function, the courts cannot function, and in effect there's a shutdown of civil government. So that is my argument. And what I cited to show that the origin of Section 82C of the Constitution of Trinidad and Tobago came from colonial days. And in colonial days, in those days, the way 82C was being interpreted was a state of emergency had to be a threat to the life of the nation. So my argument before the Privy Council is that the state of emergency in 2011 should be declared unconstitutional because it did not amount to a threat to the life of the nation. Now, I do not know how the court is going to decide. In respect of the regulation, now, as you know, who follow the Privy Council, in some cases, they are very vocal when the arguments are being made. In some cases, they remain silent and they just ask a few questions. When my junior, Robert Strang, because I said I was arguing the first point, Rob Strang would argue the regulation. When my junior got up and he started to go through the regulations, and he dealt with the regulations and how they could detain people and how they have these PDOs and etc., they were not happy at all. And if you tune on to the website of the Privy Council, you would see the exchanges which occurred during the hearing about those regulations. As a matter of fact, Lady Rose told the lawyer for the state that why it is that a minister should be able to detain someone for 7 days. If you have a state of emergency, after 48 hours or 3 days, take him before a magistrate or a judge. A minister, in other words, the executive arm of the state, is given the power to perform judicial functions. And if you have a continuous state of emergency, the executive arm of the state is performing the functions of the judiciary, determining whether people should stay in custody or not. So to me, it goes to the root of our Constitution. And I'm hoping that the Privy Council gives a decision very quickly, because it is my view that any state of emergency which is called in Trinidad and Tobago, and it does not set the threshold test of being a threat to the life of the nation, it is, in my view, not in accordance with the Constitution of Trinidad and Tobago. It is also my view that any persons arrested and detained under those regulations, if it's the same regulation, and I understand it's the same regulation which were there, was substantially the same regulation there which were in 2011. In my respectful view as a lawyer, I do not know what the Privy Council will decide. They cannot be lawful detention. So I thought it best that I would take this opportunity, since this issue is very current in the country. So I would like to thank everybody for coming and to, in effect, to witness this contribution, or this celebration for the contribution. I want to say, however, in closing, lawyers, before I close, I think I must mention something when I was Attorney General. When I became the Attorney General of Trinidad and Tobago, I got a very good opportunity to not only develop the law as a lawyer, but I got an opportunity to make laws, to persuade the cabinet and the parliament to make laws. And my friend Anand talked about it. One of the laws that I really wanted to reform was the Judicial Review Act. And lawyers here will know that when the Law Commission came to me and they brought the draft act, the draft act that I wanted to pass, they left out what I wanted. I wanted that for interlocutory decisions before the court, there should be a right of appeal to the Privy Council. Right of appeal to the Court of Appeal and a right of appeal to the Privy Council. And the Law Commission was fighting me that we should not put that in the bill. And I insisted, and I went to the cabinet and I got the approval. And Anand would bear witness to this. That section of that Judicial Review Act has caused a lot of people to get justice in the Court of Appeal and justice before the Privy Council. And as a matter of fact, the present case that is being done, the Dominic Hadid, if it were not for that section in the Judicial Review Act, there would have had to be leave to appeal. The other piece of legislation which I enjoyed doing was the Freedom of Information Act. And I do not think a lot of us in Trinidad and Tobago understand yet how much that act could be used. It cannot only be used to write and get information and then use it to file judicial review. If the government holds false and inaccurate information about you in its records, any department, that act gives you a right to go to court to have that information corrected. I had the pleasure of doing a case recently, and it's in the appeal, so I probably won't talk about it. But it gives the right to have that information corrected. And if you look at the section, I can't remember the section, so I'm telling the public through this forum that if the government or any public authority holds information against you or your client or any individual in Trinidad and Tobago which is inaccurate, you can go to the court and have it corrected. So the Judicial Review Act, the Freedom of Information Act, and the Equal Opportunity Act remains as three of the legislation that I'm very happy that I was able to have the Parliament enact so that there can be greater justice for the people of Trinidad and Tobago. So in closing, I would like to thank the Southern Assembly of Lawyers, thank all the lawyers here, thanks all those who have contributed with me in making this possible. And I want to assure you that I will be here I will be here. Well, I cannot assure you, I am hoping that I will be here in the next 20 years to celebrate what I've done for the next 20 years. Thank you.
To recognize your contribution to that young lawyer's loan.
This moment, we'd like to ask Ms. Amanda Wall to give the vote of thanks.
Good afternoon, the Honorable Chief Justice, Mr. Ramesh L, ladies and gentlemen. As our annual Luncheon draws to its close, it is my privilege, on behalf of the Executive Committee and members of, at the outset, permit me to observe that the distinguished gathering assembled here today is itself a testament to the high regard in which our guest of honor, Senior Counsel Mr. Ramesh L. Maharaj. Thank you for graciously accepting our invitation and for allowing the Assembly of Southern Lawyers to exemplify the highest ideals of advocacy, learning, integrity, and public service. We heard today of your unwavering finding ways and means to develop the law. That is something we must do and continue to do as young practitioners and even seasoned professionals.
Doctor, don't do a function like that. The association had I know we are.
No, just talk with each other. Just talk, just talk.
Make news with it. Nothing important. Making news with it. I want to.
Yeah, yeah.